I didn't have it on. Sorry. All right, good morning, everybody. My name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today you're going to be informed of the charges and we're going to determine if there's probable cause. Today is not your trial date. Please do not talk about the facts of your case. Everything is being recorded. You have a right to remain silent. You also have a right to an attorney. We have Mr. Romero, I believe, who's at the main jail, and we have Mr. Reedy, who's here to my right in the courtroom. If you have a private attorney, please let me know when you step up to the podium, and we'll see if we can get your attorney on the phone or in the courtroom. We're going to call a couple cases out of line at the request of a jail. The first one is Ettore Ferrara, page 3 of the docket. Good morning, Sheila.
Judge, he's here present.
Okay.
Good morning. Good morning, Judge.
Good morning, sir. How are you?
All right. We're trying to make it out there.
I know, it's not easy. All right, well, you have, sir, a capias for a petty theft. You failed to appear. I see some notes that say that you were in the hospital at the time of the capias being issued. Does he want to resolve his case today, Mr. Romero?
Yes,
what would you like to do?
Yes, he does. And speaking of Mr. Ferraro, I did advise him if he had a reason, as you said, we can ask for him to release our OR, but in talking to him, he wishes to resolve it. My understanding is it happened at Publix and the merchandise was recovered, so he's wishing to resolve the case today, Judge. And I...
All right, this seems like it's a second one.
It's
because it says petty firm.
I know that's what it says.
It says petite from merchants. Second.
Yeah, I know. That's what it says. He's been to prison for felony theft.
Okay.
The state's offered to be a time served, no return.
Okay. All right, sir.
To accept the state's offer.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right. You don't have any other pending cases, do you, sir?
No, ma'am.
Put your hand down. Okay. Your name is Ettore Ferrara, Ferrara?
Yes, ma'am.
All right. How do you wish to plead to petty theft, sir?
No contest, Your Honor.
You want to give up your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
Yes, ma'am.
You are? Are you under the influence of any alcohol?
Medication.
Okay. Does your medication affect your ability to understand what's going on here today?
No, ma'am.
All right. Ever been treated for a mental illness?
Yes, ma'am.
All right. Don't tell me what it is. Does your mental illness affect your ability to understand what's going on here today?
No, ma'am.
All right. You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings?
Yes, ma'am.
All right. And he's been to prison before for petty theft?
Felony theft.
So next time, sir, you get a petty theft, it could be charged as a felony. Do you understand?
Yes, ma'am.
All right. Keeping that in mind, how do you wish to plead? You said guilty, not guilty, or no contest?
No contest, ma'am.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea, adjudication, time served, $293 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case except for paying you $293, okay? Good luck to you, sir. Okay. Thank you. All right, next one is Damian McKinney, but that's a Mr. McLaurin's case, so we'll do Charles Arthur Carras, who is on page 7 of a docket.
Judge, she's approaching. This is a county ordinance case.
Oh, it is?
Yes.
Okay, hold on. We also have Damian McKinney. Is this a county or Fort Lauderdale? Let's see.
Or Charles. Charles? McKinney? Where's he say McKinney?
I don't have McKinney. It's an MO.
Oh.
Yeah, hold on one moment. McKinney. Oh, that's him too. Okay. what about, so Carras is his 2. What about Michael Imperato, page 10 of a docket?
He's here, Judge. Have a seat, sir. Your case on recall. He's approaching, Judge.
All right, let me know when Mr. McLawrence gets there and is ready, okay?
Yes, Judge.
All right. All right, sir, good morning. Are you Mr. Michael Imperato?
Yes, ma'am.
All right, good morning, sir. You have grand theft between $300 and $5,000. Bond is set at $1,000. The court does find probable cause. Court is going to order no return, sir, to the Walmart located at 555 West Atlantic Boulevard, Margate, Florida. Do you understand?
Yes, ma'am.
All right. Anybody wish to be heard with regards to the $1,000 bond?
No.
He can bond out?
No. No, Judge.
All right, so tell me what's going on here.
All I know, Judge, is he's 41 years old. He's been here living in our community for the past 13 years. At this time, he's unemployed. He's in the process of applying for disability. So, Judge, as far as his financial resources, it seems like he has none.
Okay, state, what's his priors?
It looks like he is out on bond and pretrial, Your Honor, from what I can tell. He's out on one, at least one or the other, if not both. I see he's got a pending felony theft. Yes. Okay, Your Honor, he was out on pretrial on a felony theft. He got arrested for a new theft, and Your Honor revoked his pretrial and set a $1,000 bond. So he's out on the misdemeanor theft.
So he paid the $1,000 bond.
And the $25 bond on the misdemeanor theft. So he's out on those 2 thefts. He's got, he pled out the misdemeanor theft in April, so that's not pending. He's got another theft last year, grand theft last year, 270 days. Possession of PVP 2016, 364 days. 2012, burglary of an occupied dwelling, dealing in stolen property, 33-month state prison after a VOP. Possession of cocaine, 07 with a VOP.
All right, leave it at 1,000 per the request of this. Per the request of the defense, we'll leave the bond at 1,000, no return, sir. All right, so we'll wait for that list. Let's call Keisha Simone Smith.
North Broward, I believe, Judge.
Thank you.
Yes, Ms. Smith is at North Broward, Judge. She would like to resolve these 2016, 2017 matters.
She claims wrong person. She's saying it's not me.
Who says it's not me?
Keisha Simone Smith, it says, subject claims wrong person.
Okay.
Okay, are you Keisha Smith?
I am, Your Honor.
Is your middle name Simone?
It is, Your Honor.
All right, ma'am, you have 2 capiases that was issued. One's a petty theft for $1,000. It says you had a no-show at a hearing. Bond was set at $1,000. And then you have trespass of a structure or conveyance. You had a no-show at arraignment on July 5th, 2017. What say you, defense?
Your Honor, Ms. Smith indicates to me that she's been living here in South Florida all of her life. She has a brother and sister here. She can return to a place called Open Arms in Pompano, which is an assisted, I guess, a facility. She does have family here. She does not have their phone numbers, so I can't reach them. She did give me the phone number of her aunt, who I can call, and have not had a chance to do so yet. But she indicated she would like to resolve these matters. If she wants to maintain that it's not her, I'd ask the court to consider an ROR.
Problem is she no-showed 2 separate times. And I don't know what the place was that you were referring to that she's living in, but I have a suspicion. Would this be appropriate to send to Judge Wren or just send to a regular division?
See, Judge, can you give me 1 second?
Because I was reading the probable cause. Let's go, ma'am, just hold on 1 moment, okay? So I'm not gonna accept a plea today. Let's figure out what to do. Could be Michelle today. How was your cruise? Good. Did you put that there? Oh. Yeah, that's where I put it. Oh. It's okay. So what are we doing here, Mr. Reedy?
I think to Judge Lerner Wren, I think is an appropriate destination, Judge.
All right, how do we get her in there tomorrow, or?
I think she's out till Thursday, isn't she?
Yeah, it might, I'm texting, her GA right now to let her know.
Willie will help you open it. Willie, can you help Rebecca? Oh, she got it. Thank you. Thanks, Willie. Are you waiting for?
I'm just writing the text right now.
Okay. All right, ma'am, so we'll recall your case. Just have a seat. We'll recall you in a couple minutes, okay? Thank you. All right, we have family here, page 10, Michael Caldwell. Are you Mr. Caldwell?
How you doing?
Good morning.
He's here.
All right, page 10 of the docket. Okay, you're Michael Levon Caldwell, sir?
Yes.
All right. All right, what do we have here today?
His mother, Your Honor.
Okay,
Renee
can you
Schneider.
Spell your last name?
SCHNEIDER.
Okay, and your name, sir?
Seth Penalver, stepfather.
Okay, can you spell your last name?
PENALV as in Victor, ER.
Okay, thank you very much. So did you just come here today for support, or did you want to tell us something?
No, I want to address the court. My son has mental health issues. On April 17th, I took him to Broward General, and I personally walked him in and begged them to help him. He begged them for help, and essentially, they basically put him in the psych ward for 2 days and medicated him until they felt he was no longer a threat. He has mental health issues. He has drug, issues, and he needs help. I've begged, I've pleaded. They referred him to BARC. It's just escalated to the point where it's just going to keep happening until somebody steps in and gets him help. I've tried. When he was younger, he was too young for this program. He was too old for this program. He hadn't been in enough trouble. He's been diagnosed with depression when he was 12. He's got ADHD. He's got short-term memory loss. He needs help. He doesn't need a prison sentence. He needs somebody to help him.
Okay. All right, well, why don't we have the state go first, and then the defense, and let me just tell him what he's charged with, and then we'll let you and his stepdad speak further if you want, okay? All right, you're welcome. All right, Mr. Caldwell, you have battery on an officer, firefighter, EMT. We need to talk about bond. Counts 2 and 3 are basically RORs. There's no bond attached to it. It's disorderly conduct. Brawl, fight, corrupt, public moral decency. That's basically an ROR. And then you have resistant officer or obstruct without violence. The court does find probable cause. Anybody wish to be heard with regard to bond? State?
Your Honor, I'd be requesting a $1,000 bond. Mr. Caldwell, he has 2010 burglary of a conveyance, 2010 burglary of a dwelling with a battery, 2008 criminal mischief.
All right. Mr. Reedy or Mr. Romero?
Judge, certainly I think I agree with Mr. Caldwell's mother that jail is not going to help him. My understanding, I haven't reviewed the PC affidavit, but I believe initially the police were summoned to try and help Mr. Caldwell. I don't know what went wrong, and he was eventually arrested. Having said that, Judge, as far as Mr. Caldwell's financial resources, from what he advised me, he had a job interview scheduled for this week at a restaurant called Aruba's. He was employed previously at Boat Campers for over a year and a half. Right now, he's 28 years old. He's been working here his whole life. He's not in a financial position to post his monetary bond. He's going to be depending on his family to help post his monetary bond. So therefore, Judge, I don't know if we can inquire with his family as far as their financial resources in order to post bond. But I know Mr. Caldwell did advise me that he's looking forward to his day in court. He believes that the police were summoned to give him help, and he's been arrested, Judge. So he's kind of at a loss right now as far as why this happened to him. But he's here today, and he's hoping this court would consider the totality of the circumstances. And also, Judge, we'd be asking you to sign an order allowing us to photograph the injuries that Mr. Caldwell sustained.
Sure, the court will grant your request for a photograph to show the alleged injuries he sustained. So, what is it that you're asking for then? He has a prior record.
I know he has a prior record, Judge, but he's not in a financial position to post his bond. I don't know if his mother's going to be posting his bond. I don't know if she has. I know the state suggested $1,000. I don't know if maybe considering the circumstances, Your Honor would consider releasing him under pretrial release. So therefore, he'll be under supervision. Maybe that the supervision, maybe that hopefully his mom is wanting. And you could go ahead and schedule conditions as far as him appearing, reporting, making sure that he's, I guess, not picking up any sort of new law offenses or anything like that, Judge. So at this time, I believe maybe pretrial release may be appropriate for Mr. Caldwell.
Your Honor, I just also want to just bring to the court's attention some concern. If I could refer the court to his booking sheet, direct the court's attention to pretty much in the middle where it says intake comments.
Hold on.
It's a little bit above where it has the charges. They weren't even able to book him. They had to book him based on the probable cause affidavit because he was acting violent.
One moment, sir. I'll give you an opportunity, don't worry. So you'd rather, can you afford the $1,000 bond?
Yes, Your Honor, the $1,000 bond is really no issue here, and I know we're going back and forth with it. What I would respectfully maybe ask the court if you could consider is maybe order a mental health evaluation and maybe a condition of pretrial release with the bond is maybe to test him for condition of the release, so that we could try to get help. We're reaching out for help here. The money, it could be a $10,000 bond. I'd post a bond. It's just, we don't know who else to reach out to. Obviously, you see that even the state acknowledges, everyone acknowledges that he was called for help. And when we're dealing with a patient that has mental health issues, sometimes it does turn violent, as we see on the news and the media all the time. But law enforcement does the best that they can, you know, and he does have mental health issues, so probably didn't go good, you know. Not accusing cops, not accusing him, you know. He has mental health issues. That's our main concern.
We stand here today again a month later. A month ago was the first time he's ever acknowledged he's had health issues and mental health issues and that he needs help. He willingly went in to get help, and he's had mental health issues since he was little, and this is the first time he's actually asked for help. We need help to get him the treatment he needs.
Okay, any objection to an evaluation?
No, Your Honor, I don't think Mr. Romero or I would have an objection to that.
Okay, and what else is it that you're asking for? They said they can post the $1,000 bond. I'll do a psych eval within how many days?
Well, if he's going to be on pretrial release, Judge, he'll have to report within 24 hours of his release from the jail. I assume the court is placing him on pretrial release.
I haven't decided that yet.
Okay, well, if you
That's
do,
what you're
then they would set
requesting.
it up. If not, he'll have to set it up on himself. So I would give him 10 days.
Okay, so I'm gonna put him on standard pretrial release. Psych eval within how many days?
If he goes to pretrial release, I think they can probably set it up for him within a couple of weeks.
Can you give me a days to put in here? I want to put some time limitation, so it's performed. Hi.
Sooner the better if it's possible, but I understand you guys are time constrained, and I appreciate it.
All right, the court will order a psych eval within 7 days. Standard pretrial release, $1,000 bond. No firearms, ammunition, or weapons. If you do have any, sir, when you're released, you're to surrender them immediately to your local police department. Do you understand? Okay, you are to follow any recommended treatment until further order of the court. Do you understand, sir?
I'm sorry, Judge, I was talking to him, I didn't hear, I'm sorry.
Okay, I said psych eval within 7 days, standard pretrial, no firearms, ammunition, or weapons. If he has any when he's released, he has to immediately surrender them to his local law enforcement. Follow any recommended treatment until further order of the court, okay? Anything else from anybody? No? All right, is his address 211 Southwest 22nd Street?
We're gonna be requesting his mother's phone number, so when he's released, he can contact his mother. So if my colleague can call me, so I can write that number down for him.
Yeah, I'm going to get it anyway.
Okay. Thank you, Judge.
Thank you. All right, is that his address?
No,
What is it?
1236 Southwest 32nd Street.
Okay, I'm writing it down, so if you could say it a little slower.
Oh, sorry, 1236
Okay,
Southwest 32nd Street, Fort Lauderdale. But more than likely, he's going to be staying with me and Davy. That's my sister's address where everything happened a couple days ago.
the 1236.
Correct.
But is that where he gets his mail to appear in
Yes.
court? Because he's
Yes.
going to get a notice,
Yes.
and if he doesn't appear,
Well, we have a P.O. box. If you want the P.O. box is where he gets all of his mail.
well, what's the fastest way?
The P.O. box. I check it every day.
All right. So, P.O. Box, go ahead.
It's 6278
Uh-huh.
North Federal Highway,
Post office box,
PMB, private mailbox, 479
6278.
North Federal Highway, PMB,
Hold on,
479
PMB.
Fort Lauderdale,
What's the PMB?
private mailbox.
Okay, so it's I have PMB 6278.
The address is 6278 North Federal Highway,
Okay, PMB.
PMB 479, Fort Lauderdale, 33308.
All right, I'll have his address updated by the clerk forthwith.
And if my colleague, the phone number, Judge?
I'll get it.
All right, you have to report within 24 hours, sir, to pretrial release, okay?
Yes.
All right, good luck to you.
Thank
so
you.
much.
Okay. Okay, next one, Sherry Jean Sherman, please. Good luck to you. Sherry Jean Sherman, please. Someone tell me where she is?
Medical reset.
Thank you.
Medical reset.
Medical reset. You're welcome. Erica Marina Lovesmith.
Also North Broward, Judge.
Okay. Hello.
Hi, how are you?
Good. Are you Erica Marina Lovesmith?
Yes.
All right. You have one count of possession of cocaine, $1,000 bond. Count 2 is possess and/or use drug paraphernalia.
Yes, ma'am.
Hold on one moment. Mr. Romero? You have the mic on. We can't hear it, North Broward. That's okay. All right. Sorry, ma'am. I was hearing a lot of feedback from the main jail. So you have a charge of possession of cocaine, $1,000 bond. Count 2 is possession and/or use drug paraphernalia. There's no bond attached to that. You do have the probation violations. That's for May 23rd, which this cover sheet doesn't have. Is there any reason for that? Can someone tell me?
I'm sorry, Judge?
When I go to her cover sheet, it has counts 1, 2, 3, and 4 on the medical reset over the weekend, and it said she was going before her division judge in Division FB, Michael Rothschild, this Wednesday, the 23rd at 9 a.m. This cover sheet I have, do I need to magistrate her on the 2 VOPs?
If she haven't been, yes.
All right, you also have 2 probation violations, which you are going before your division judge. You're going to be held no bond on those. The court does find probable cause. Anybody wish to be heard?
No, Your Honor, I spoke with Miss Lovesmith before court, and there's nothing else. She has no bond hold, so there's not much else
All
to
right,
say.
$9.99 on the possession of cocaine. You will see your, hold on, ma'am. You're going to see your division judge May 23rd at 9 a.m., okay?
Yes, ma'am.
Did you have a question?
My division judge has changed.
I have it as Michael Rothschild. I don't know. You'll probably find out on Wednesday. Does anybody have any knowledge? Did she go with someone else?
Odyssey says it's Judge Duffy.
Yeah, and that's what it says on the booking.
All right, it could have changed, so maybe you want to send an email to her public defender so she doesn't get lost in the shuffle. Can you do that, Mr. Reedy?
I will see what I can do, Judge.
Thank you. All right.
Thank you.
You're welcome, ma'am. Good luck to you. Monique Michelle Handel,
Medical reset.
how are you? 521. Bryson J.A. Tarvis White.
He's approaching, Judge. He's here at Maine.
Okay. Hello, Mr. White. How are you?
I'm good.
All right, sir. You have petty theft, second degree, first offense. There's no bond attached to that. You do have possession of cannabis, 20 grams or less, $100 bond. Court does find probable cause.
Judge, we'll ask for an R warrant on the cannabis offense. I don't know if the state has an objection to that.
Yeah, the issue, Your Honor, is he was just picked up April 24th on a violation of pretrial warrant for a separate theft and unlawful use of false name ID. He was ROR'd on that just last Tuesday, and now he's back here on, and frankly, the cannabis isn't my concern, it's the theft. And before that, he was arrested, let's see, March 21st on a capias for possession of cannabis that he bonded out on $300. He had bond surrendered on another case December of last year when he was arrested on a new theft. Capias.
Which case is he out on pretrial release?
That would be 17-11450 MM10A, theft and unlawful use of false name ID.
And he's on, when was he placed on pretrial?
I'd have to check Odyssey to get the exact date. He was placed on pretrial December of last year. The affidavit was signed in April by Judge Diaz. He failed to submit to random testing. He didn't call pretrial twice a week. There was a $1,000 total bond on the warrant, and then on May 15th, Judge Diaz ROR'd on the case.
So he's not on pretrial?
No, he was on pretrial. He was arrested for violating, then he was ROR'd.
All right, sir, there's gonna be no return to the Marshals, 4197 West Commercial Boulevard, Tamarack. Can you bond out of jail for $100?
From what you advised me, no. As you heard, I believe he was in custody for over 30 days before I believe Judge Diaz ROR'd him. So financially, no one's going to be able to afford to post his bond, Judge.
So he gets out and then he goes and allegedly commits another crime. And what are you asking for?
Judge, still my initial request. You're here, we're facing a cannabis offense and a misdemeanor petty theft. Total bond is $100. We're asking for an ROR because you can't monetarily post the bond.
Standard pretrial release. See at 6723 Bayfront Drive, Margate.
Is that your address, sir? Yeah.
All right, I'm putting him on pretrial release. He's to report within 24 hours.
Your Honor?
Yes.
Okay. Just so the court's aware, on the, that looks like an address he should be at, right? That's his ROR. That looks like the address he should be at, right? Mm-hmm. Just to let you know, Your Honor, there's Judge Diaz wrote in a Lauderhill address on the order granting the ROR for May 15th.
So which is which?
I believe one of the addresses, Judge, is aunt. Yeah. Which one's your aunt's address? That's my aunt's address. So you can get mail from there? Yeah. I guess you can still get mail from there. Just send it.
All right, that's fine, no problem. Thank you, sir. Good luck to you.
All right.
Tobias Facco Gutierrez. Mr. Gutierrez.
He's in North Broward, Your Honor. He'd like to resolve these matters if possible.
Okay, state what's your offer.
On count one, it'd be a withhold.
Pardon? Madam Clerk? Yeah, one's an MM and one's an MO. All right, sir, you want to resolve your cases today?
Yes, ma'am.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Tobias Facco Gutierrez, Gutierrez?
Yes, ma'am.
All right, it's my understanding you wish to waive your right to a trial in the possession of cannabis under 20 grams charge?
Yes, ma'am.
All right, and you want to waive your right to an attorney and a trial in the in the open container, the municipal ordinance charge?
Yes, ma'am.
Okay, you understand that you don't have to plead any of these charges today. The court will ROR you, and you can come back and have your day in court.
Okay, whatever it is, Your Honor, because I just want to tell you the reason why I wasn't able to show up to those court days was because shortly after that, I asked my family for help, and they sent me to Arizona to a substance abuse program. I've been there for 2 years. I just got back, and I've been sober and clean ever since.
All
That's
right,
something that's hunting me back from
so
the
do
past.
you want to fight your charges? You want a
No,
trial?
no, I just want to take care of this. This is something in the past. I'm starting anew. I've been sober for 2 years now. And this is something that I just want to get it over with.
All right, is this your only thing that's pending, these two cases?
Yes, ma'am. That's it. Everything else I took care of. I did actually, when I came back from Arizona in December, I looked online to see if I had anything, and this never showed up. So, but it's okay as long as I can take care of it.
Okay. All right. So is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings, sir?
I'm a U.S. citizen, ma'am.
Okay. All right. How do you want to plead to possession of cannabis under 20 grams in open container?
No contest.
Okay, the court is going to accept your plea, find this freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court is going to withhold on the possession of cannabis charge and impose $308 in court costs, which I have to by law. The court will give him 6 months to pay. Then we have the open container. The court is going to adjudicate you and time serve you. The court has to impose court costs on count 2 in the amount of $78 and give you 6 months to pay that as well.
So that would be a total of 400?
$308 and $78.
Okay.
Okay?
Yes, ma'am.
You can pay them in partial payments online through the clerk of the court, okay? If you don't, they'll suspend your license and you'll get arrested again.
Oh, yes. That's fine.
Okay? So I'll give you 6 months to pay on each one, so it's $308.78. Court will take judicial notice of the time that you served in the Broward County Jail on the possession of cannabis under 20 grams. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck, sir. You're done with this case except for paying your court costs. Okay?
All right, thank you.
Thank you.
Judge?
Hold on.
No, not on this, before we move on. You asked me about Keisha Smith. You put her on recall.
Oh, okay.
I'd spoken to, I noticed Judge Lerner GA. Judge Lerner isn't having court till Thursday. She'll see her in court on Thursday. In the meantime, her GA is contacting the jail to have Armor take a look.
Okay. All right, so this is what we'll do. Let's get Keisha Simone Smith back. So she is set for Thursday, right?
That's when she has court next. I don't know.
Can we get her on that day?
Patrice, I think her Jay's on schedule, but if you could maybe as backup, Patrice, if you could pass it along to have someone from the clerk's office schedule her, please.
Can we get Keisha Smith back? Okay. Hello, Ms. Smith.
Hi.
All right, Ms. Smith, we're going to send you to Judge Wren. You are going to have a court date on May 24th. I don't know if it's going to be the morning or the afternoon, and she'll be able to help you. She'll be in a better position to help you more, ma'am, and give you more services that you need, okay?
Okay.
All right, so we're going to leave your bond at $1,000 and then $500, total of $1,500. And you can talk to Judge Wren about lowering them. Okay, ma'am? Thank you. Okay, Mr. Reedy, you might want to reach out to her grandmother, you said?
Her aunt, yes, I will, Judge.
Her aunt, because, you know, she might be in jeopardy of losing her space
Right, I'll give her aunt a call as soon as court's
of
over.
the facility she's in. Okay. All right, next one is Shamal Rubain. Shamal Rubain.
He's here at Main, Judge.
Ah, there's Mr. McLawrence. We'll take it. Hi, we're gonna take your cases after this, okay? Okay, are you Mr. Shamal Rubain, sir?
Yes, ma'am.
All right, you have possession of cannabis, 20 grams or less. You failed to appear in court. You want to resolve your case today?
Yes, ma'am.
Okay, state, withhold.
Yes, ma'am.
All right, does he want to resolve?
Yes, Judge.
Raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Shamal Rubain, Rubaine?
Yes, ma'am.
All right, you want to resolve your case today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
All right, you understand what's going on here today, correct?
Yes, ma'am.
All right, how do you wish to plead to possession of cannabis under 20 grams? Guilty, not guilty, or no contest?
No contest.
All right, court's going to accept your plea. Find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Court's going to do a withhold and court costs of $308. Court will take judicial notice of the time that he served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Good luck, Judge.
All right, Mr. McLawrence, let's get to yours. Charles Arthur Carras, please. Is he okay? The mic's off.
What's that?
Charles Scares.
Judge, I don't think I represent Mr. Karras.
He has Broward County ordinance.
Oh, yes, Judge, you're right. I haven't had a chance to speak with him as yet, Judge. Could I do the Fort Lauderdale MOs?
Sure.
Just give me 1 second, okay? Have a seat.
Norma Jean McFadden.
She's here in the main jail, Your Honor.
All right. Hello, good morning, Miss McFadden. How are you?
All right, how are you?
Good. You have a possession of drug paraphernalia. What's her priors, Mr. McLawrence? Does she want to resolve?
She does want to resolve, Judge, and she indicated to me that the address to which the notice was sent was the wrong address. But, Judge, I was going to ask if the court would withhold and take judicial notice of time served. This is a municipal ordinance possession of drug paraphernalia offense.
What's her prior record like? Anything extensive? Do you know?
Are you asking me, Your Honor?
Yeah. Or I can ask the state to look it up.
Is she McFadden? Is her last name McFadden?
Yep.
All right.
Norma Jean.
Okay. 2016, she had a prosecution case, conviction. 2014, another prosecution, possession of drug paraphernalia. 2014, trespass. 2013, prostitution. 2013, another prostitution case. 2012, trespass, prostitution.
All right, court will do, thank you so much. Adjudication time served, $78 in court costs.
Yes,
No, you have to let her know.
yes, ma'am, I will accept that.
Raise your right hand, ma'am. Do you swear and/or affirm to tell the truth?
Yes, ma'am, I will.
Your name is Norma Jean McFadden, MC, F-A-D-D-E-N.
Yes, ma'am.
All right, it's my understanding you wish to waive your right to a trial?
Yes, ma'am, I will.
You can put your hand down. Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs?
No, ma'am.
Never been treated for a mental illness?
Yes, ma'am.
All right, does your mental illness affect your ability to understand what's going on here today?
No, ma'am, it doesn't.
All right, you're doing this freely and voluntarily, right?
Yes, ma'am.
All right, how do you wish to plead? Guilty, not guilty, or no contest to possession of drug paraphernalia?
No contest, ma'am.
Court's can accept your plea, find that's freely and voluntarily given. Court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate your time, serve you $78 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, ma'am, except for paying your court costs. Thank you.
Thank you, ma'am.
You're welcome. All right, have you had an opportunity to speak to Mr. Perez?
Not yet, Judge. I
Okay.
do have Damian McKinney, though. I've spoken to Mr. McKinney on page 3 of the docket,
Okay.
and he's here in the main jail.
Okay, good morning, Damian McKinney. Good morning, sir. You want to resolve your case today?
Yes, ma'am.
Okay, Mr. McLaurin, adjudication, time served.
Judge, I was going to ask if the court would consider withholding. It's a possession of marijuana offense.
It says possession of controlled substance. Let me look it up. I don't believe this is a 2-year driver's license. It says possession of controlled substance.
Okay, I'm just looking at the PC, and according to the police officer, it was a small clear plastic baggie containing brown leafy substance, Judge. So that's why I was asking for the withhold.
It's possession of controlled substance unless you can tell me that. Go ahead, State.
It would appear, and you're both right, in this instance, controlled substance alleged is marijuana.
But that's an adjudication of that wouldn't be a 2-year suspension,
I
it
think
would?
I think it would.
Okay, withholding court costs.
Thank you, Your Honor.
Yes, ma'am.
I'm going to speak up, man.
All right. So, sir, let's start from the top. Raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Are you Damian McKinney, MC, Kinney?
Yes, ma'am.
It's my understanding you wish to give up your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
All right, you're doing this freely and voluntarily, you said, right?
Yes, ma'am.
How do you want to plead? Guilty, not guilty, or no contest to possession of controlled substance?
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Court is going to withhold adjudication and impose court costs of $78. Court takes judicial notice of the time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Thank you.
All right.
Judge, also, Judge, also on page 4, there's a Benny Hopwood, and I was told that he was sent to his division judge, but the division judge looks like it would be Judge Wren, and she won't be in until Thursday, so I'm not quite sure where he is, but
yeah, he was taken off our docket. Supposedly, there's coverage. You might want to see if another judge covered it, because when a judge is out for the VOPs, they're supposed to have substitute coverage. If there isn't, get back to me and we'll put them on my docket and do something, okay?
All right, Judge, if I could just have 2 minutes, and I'll call.
Sure, let me know when you're ready. We're going to go to the next
Thank you.
person. Thank you. All right, I don't know what page we're on now. We're going back to the
4.
regular docket. James Clayton Roberts is who you have next.
Yes, Your Honor. He's in North Broward. He would like to resolve this case.
All right, State, you have an offer?
Yes, Your Honor. The state's offer is 15 days county jail. Your Honor, and it's mentioned in here, he was just before you May 7th. He, on a trespass, 2 counts of trespass resisting without violence, same location. He pled up to 10 days. Every time before that, it was April 30th, same place, the Davies Supermarket. He just refuses, and it mentions actually in here that he's been
Hold in bond court.
Yeah.
All right, 15 days, Broward County Jail. I mean, he's been given so many opportunities.
The court considers nothing less than 15 days?
If he wants to go to the community resource center, the court will do 10 days.
All right, Mr. Roberts, if you want to go to the Community Resource Center, which they will take you to upon your release, they've got a hot shower, watch TV, wash your clothes. They'll help you maybe set up with some housing or some help if you need some help. If you want to go there upon your release, the judge will give you 10 days. Or you can maintain your plea of not guilty if you want.
No, I plead guilty, but what about my lung cancer? I need my medicine.
I'll make a notation that you. I don't know if they're going to give you chemotherapy in jail.
I need that. 'Cause they're gonna, I'm
He
gonna
does
die.
have a, from what he tells me, Judge, he does have a pretty serious health issue.
We can get
I'm
him
gonna
a
die.
we can
I'm
get
gonna
him
die
a
anyways.
screening.
Yeah, we can get a medical screen.
You can do an order. All right, sir, do you want to, you can get a medical screening at the jail. That's the best I can do for you. You want to take a plea of 10 days, sir?
I guess so, but I need my medicine, ma'am. I'm gonna die.
They might even be able to help you with that issue at this outreach center, Mr. Roberts.
What's that?
I said they might be able to help you arrange for medical services as well at this outreach center.
How long will I be there?
It's voluntary. You can leave at any time.
Okay, where's that at?
It's at US 1 and
441 Lauderdale Lakes. Starts
441.
April 7.
Is that up here?
It's not far.
What would you like to do, Mr. Roberts?
Plead guilty.
Okay. And do you want to go to the program, the community outreach program?
Yeah.
Okay. All right, Judge, I believe Mr. Roberts would accept the court's offer. He'll be willing to give up his right to a trial by jury, enter a plea of no contest in exchange for 10 days
sir,
Broward
raise
County
your
Jail.
right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Your name is James Clayton Roberts.
Yes, ma'am.
All right, you may inquire, Mr. Reedy. I'm going to write up the order here.
Oh, okay. I was going to do it, Judge, but if you want to do it, that's fine. Mr. Roberts, do you understand what's happening here this morning? You understand you're charged with trespassing?
Yeah.
Okay. Do you suffer from any type of mental illness?
No, just cancer, boss man.
Okay. So you have a physical issue, right?
Yeah, I'm gonna.
Okay. All right. I understand. I understand.
No, I'm gonna die. I need my medicine.
Do you understand that you have a right to a trial by jury in this case, and by entering this plea, you're giving up that right to a trial? Is that what you want to do? And how do you want to plead to this charge? Guilty, no contest, not guilty.
Guilty, right?
Okay.
Okay, the court's going to accept your plea. Find that's freely and voluntarily given. The court has reviewed the court file and finds probable cause for the plea of trespassing, failure to leave property on order by owner. The court is going to adjudicate you, give you 10 days in the Broward County Jail. Court will give you credit for time served.
How much time served, ma'am?
You're going to be released on the day, the way I look at it,
The 28th.
on May 28th, okay?
Okay, ma'am.
All right, you'll be released, transported to the Central Receiving Center. I think you'll really find it helpful, sir, at 9 a.m. You're not to return, sir, to the Davies Supermarket. If you go back there again, you know what's going to happen, right?
Yes, ma'am.
What's
Now, that place, is that Fort Lauderdale?
It's Lauderdale Lakes. It's right on the cusp. It's a nice facility, sir. I was there. They'll give you a shower, they'll wash your clothes, they'll give you new clothes if you need them, and they have a lot of assistance, okay? You can watch TV, they feed you, you really like it, okay? You know, you can leave, just give it a chance.
Okay, when do I go?
You're gonna go, what day is it? May 28th, you said, Sheila?
Yes.
May 28th.
Judge, what is the actual name of the program?
When's the 28th?
Centralized Receiving Center.
Thank you, Judge.
You're welcome. I have a brochure if you'd like.
I would, actually.
All right, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir. Good luck to you.
Good luck, Mr. Roberts.
Yes, ma'am.
Give me one moment. so if you could just put the style of the case in here, put his name, like that, and then put this charge, okay? All right, so next person, let's go back to Mr. McLawrence.
Mr. McLawrence, I believe, is right now walking to the courthouse, Judge.
Oh, okay. All right, so let's do the next one then, is Ricardo Gonzalez Ventura.
Mr. Gonzalez is here at Main, Judge. He's approaching.
Okay. All right, Mr. Gonzalez Ventura, how are you today, sir?
How are you?
Fine, thank you. Sir, you have DUI, alcohol, or drugs, first offense, $500 bond. Count 2 is operating a motor vehicle with a license plate expired. It's basically a ROR. Any objection to probable cause?
No, Your Honor.
Court does find probable cause. Anybody want to be heard with regard to the $500 bond?
Judge, my understanding is right now he was arrested without his phone, so he has no way of contacting his wife. So I'm going to ask this, to see if the state has an objection. I believe he has $100 in property. By the time they took out the money, I believe he'll have $50. So I'm going to ask if the state has an objection to lowering the bond of $50 or in the alternative, releasing him straight to pretrial release.
Final pretrial.
Okay, standard pretrial release. Thank you.
Thank you, Judge.
He has to report. Sir, you have to report within 24 hours. Let me just verify his address. 1180 Madison Chase.
Yes.
Is it Madison Chase as something else?
Apartment 5, West Palm Beach.
All right, but it's not Madison Chase Street or Drive or anything?
Oh, that's the apartment.
All right, just wanted to make sure. Good luck to you, sir.
Thank you.
Okay, so standard pretrial release. Sheila, what do you need over here for the case number? Oh, wait, do we have a case number?
For who?
You will? Okay, perfect, thank you. Steven Alexis.
Mr. Alexis, come on up, please.
All right, Mr. Alexis, you have possession of cannabis, 20 grams or less, $100 bond, count 2, driving while license is suspended. Second offense, no bond attached to that. The court does find probable cause. Anybody wish to be heard?
Judge, is possession of cannabis a $100 bond? We're going to be asking if the state has an objection to an ROR.
I do, Your Honor. Again, my concern really isn't the cannabis, it's the DWLS. This is his, he just pled out a DWLS May 1st of this year. He pled out another DWLS from last year on February 2nd. He just continues to drive without a valid license.
It says address 3600 Northwest 34th Ave, Lauderdale Lakes.
Yes.
Yes, Judge.
All right, any apartment number attached to that?
Is there any apartment or that's yes? It's a house, Judge.
Does he rent?
No, Judge, he lives with his parents.
They can't afford a $100 bond? He'd rather go on standard pretrial release and pay a $100 bond?
And my understanding, he gave me the phone number of mom just in case if you weren't inclined. He was going to say, I don't think my mom has $100. So I thought the safest bet for him to be released would be asking for pretrial release.
I'm fine with pretrial.
Okay. Standard pretrial release. If he wants to call his mom, let him. We can change it, okay?
Thank you, Judge. Thank you, Judge.
Thank you. Sir, you have to report within 24 hours, tell him.
Okay, within 24 hours, that's the map. Good luck, sir.
All right, we have Charles Arthur Carras. We have Mr. McLawrence here.
Good morning, Judge.
He's approaching, Judge.
Judge, could I approach Mr. Karras with you?
Okay, let's. Moment, okay? Give me one moment. Mr. Karas, come on up. Raise your right hand. Do you swear and/or affirm to tell the truth? Okay, hit the button there, sir. Do you swear and/or affirm to tell the truth, sir? You said yes?
Yes.
All right, put your hand down. Your name is Charles Karas, K-A-R-A-S.
Yes, ma'am.
You want to resolve your case today?
Yes, I do.
You understand that if you want, you don't have to resolve it. I can release you on your own cognizance, or we can resolve it today for a withhold of adjudication. What would you like to do?
No contest.
Okay, so you don't want a trial, correct?
No.
All right. Anybody forcing you to do this?
No.
You doing this freely and voluntarily?
Yes, ma'am.
All right. How do you wish to plead to having an open container by a licensed establishment? No contest?
Guilty. No contest.
Court's can accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Court is going to withhold adjudication. Court is going to take judicial notice of the time that you served in the Broward County Jail. You have $78 in court costs that I have to impose by law, sir. I am going to order that Mr. McLawrence do an order that Broward Sheriff's Office transports Mr. Karas to Broward General Hospital if he's delayed more than how many hours, Mr. McLawrence? He is to be screened medically.
I don't know how long it takes for BSO to process, Judge, but I imagine it's 6 to 8 hours.
Just put expedite on it. We'll make
Expedite?
sure you get it. I'll have somebody come pick it up.
All right, thank you.
All right, so if he's not released by 3 p.m. today, he's to be screened medically by
Come by here.
Armor at the jail, okay? Thank you.
Okay, thank you, Judge. All right, Mr.
Thank
Karas.
you. Good luck, sir. Do you have an order appointing you, Mr. McLawrence?
Yes, I'll bring it to you.
All right, and I'll give you this if you want. All right, next one's going to be Chuck Leah Forbes, please.
He's approaching, Judge. He declined the services of the public defender.
Judge,
Okay.
just for the record, just to let you know, he is being charged. I don't know what it is.
He's being ad charged?
Yes, but I
Do
don't
you
know
hear,
what it is.
do you hear this,
before
sir?
No.
All right, can you hit your mic? All right, let me just tell you what you're being charged with. You have Chuck Leah Forbes, correct?
Yes, ma'am.
All right, sir, you have count 1, resisting an officer, obstruct without violence, $100 bond. Count 2 is trespassing occupied structure or conveyance. There's no bond attached to that, which basically means it's an ROR. Court does find probable cause. I'm hearing from Sheila from confinement. Sheila, what were you saying?
You're being ad charged, sir, and I'm not sure what the charges are and where it's from.
I think it's a. I think it's a, yeah, it's a, I suspect it's a warrant out of St. Lucie County for failing to appear in a DWLS. It shows Florida pickup only, so I think that's probably what it is.
Okay. All right, so supposedly there's a charge coming out of St. Lucie County. Does it have a bond amount?
It's no bond.
So you have a no bond hold. Supposedly coming out of St. Lucie County for driving while license is suspended. I can tell you, sir, the court does find probable cause. The court's going to order no return to the Richards Motel at 1219 South Federal Highway, Hollywood, Florida. Do you understand?
Yes, but there was also an altercation that happened there with Hollywood PD.
All right, sir, don't talk about the facts of the case.
So I have another question, Your Honor.
Sure.
About Port St. Lucie, are they coming to transfer me there, or what's going to happen with that?
And Your Honor, I suspect that's what it is. It hasn't. I don't want to, make any guarantees that that is what it is. So before we start getting into.
Okay, you're gonna
questions
get
like
ad charge, you're gonna be held, there, you'll be coming back to, does he come back here to be magistrated, Sheila, on that?
If it's, not
St.
if it's
Lucie
a,
County driving while license is suspended?
no, but I'm
Yeah,
not
I
sure
just-
what it is, so.
Sorry.
I'm not sure what it is. but
Okay, we're
if
not
it
sure
is,
what it is, sir, you'll be
then no.
magistrated in the next day or two, and you'll find out what it is, okay?
Thank you.
Thank you. Oh, court is gonna set bond on count one at $99.
You wanna send it over?
Defendant,
I need to have him stop by here. Oh, okay. Okay.
okay. Thank you, sir, good luck to you. Next one is Alec Carlisle Wade, please.
Mr. Wade, come on up, please.
Just bring him up here, Mr. McLawrence. Okay, Mr. Wade, you have count one, possession of cannabis, 20 grams or less. $100 bond, counts 2 and 3 are disorderly intoxication. Public place causes disturbance, no bond attached, and then trespass, failure to leave property or upon order by owner, which is basically an ROR as well. Court does find probable cause. Hello. Anybody wish to be heard?
Judge, my understanding is this is Mr. Wade's first contact with the criminal justice system. Considering these are nonviolent offenses, possession of cannabis offense, I'd ask you for an ROR, Judge.
State?
He has no adult history. I have no objection to that. Just ask if, and I apologize if the court already has, order no return to the listed
Give me the address. No return to where?
4550 Southwest 23rd Street in Fort Lauderdale.
Did you hear that address, sir?
You heard the address?
Yeah, I know it.
All right, you know what happens if you return there?
You know what happens if you go back there?
Yeah, I do.
You get arrested. Your address?
Yeah, I know.
3608 Southwest 21st Court,
Yes.
Fort Lauderdale?
Yes, ma'am.
All right, ROR, you'll get your court date in the next 7 to 10 days. Thank you. Next one is Kenneth Avery Parsons.
Judge, one other quick matter. My understanding is that the address that he's not supposed to return Mr. Wade is his vehicle. Can you go back there one time with law enforcement to retrieve his vehicle?
He can return without law enforcement.
Thank you, Judge.
Get my car.
Just to get your, don't have any contact with no one, just get your car and leave.
One time.
Yes, Judge. Mr. Parsons is here, Judge, and this is a municipal ordinance case.
Okay. All right, Mr. Parsons, how are you, sir?
Okay.
You have a no-show at arraignment. You're obstructing pedestrian traffic. State, does anybody know what his prior record is?
One moment, Judge. He's been to state prison. Was released on a burglary dwelling, 2016. Had a attempted second-degree murder in the mid-90s. 9-year state prison.
Give me one moment, sir, okay? Madam Clerk, it says obstructing pedestrian traffic, and then when I look at offense, it says disorderly conduct. You need the case number?
It's, Your Honor, as a friend of the court, looking at the city information that was filed, it appears you're both right.
What?
It says here, engaging disorderly conduct by congregating on a public street or sidewalk to unreasonably obstruct or interfere with vehicular or pedestrian traffic. It's both. It's a tomato charge.
Is your address 4021 Southwest 26th Street, Hollywood? All right, this is what the court's gonna do. The court's gonna ROR you and allow you to go to your division judge to resolve what your charge is, okay? You'll get a notice in the mail in 7 days. Court is gonna appoint Stephen Shade. I am gonna appoint a public defender for you. You can't afford an attorney, can you?
No.
Okay. All right, so do you have a phone number when you get out, sir, I can give for Attorney Shade?
954-99-1498.
Okay, you're gonna have to say it a little slower for me, sir, because I'm writing it down. 954.
989-1498.
And is that your number?
Yes.
Okay. All right, sir, you'll be getting a call from Steve Shader, his office, okay? Good luck to you. You'll get a notice in 7 to 10 days. Don't miss your court date, because you know what's gonna happen. You're gonna be right back here again, okay?
Okay.
Thank you. And Madam Clerk, if we could put, so Mr. Shade has it, his phone number, I wrote it on there, okay? Thank you so much. All right, Andre Vegas, please.
Medical reset.
And Your Honor?
I thought we sent him to Judge Lerner Wren on Friday.
Yeah, Judge Lerner Wren actually transferred him to her MI division, and I think also that's to have him evaluated, I thought.
So what's going on with him?
Well, do you have a problem with the court
Just send him to
proceeding?
Judge Lerner Wren. I thought we did
All
that
right,
Friday.
so let's do this. I'm gonna put defense waives appearance, defendants appearance, okay, court does find probable cause. Case transferred to Lerner Wren. When was it transferred?
Last Friday,
Give me a date.
18th.
5/18/18. All right, thank you. Kenzo Mellis.
Medical reset.
William Wayne Young.
He's approaching, Judge. He's here on me.
Okay, good morning, Mr. Young. How are you today, sir?
Okay, ma'am.
All right, sir, you have count one, retail theft, $300+ coordinate with others, $1,000 bond. Count two is resisting an officer or obstructing without violence, $100 bond. Count three is tamper with or fabricate physical evidence, $1,000 bond. Count four is possession of anti-shoplifting control device countermeasure, $1,000 bond. Count five and six, sir, are a probation violation. You're going to be held no bond on 5 and 6. You do have a hearing coming up in front of Judge Andrew Siegel on May 23rd, which is this Wednesday, sir, at 8:30 a.m. Court does find probable cause. Anybody wish to be heard?
Not at this time, Judge, considering his no bond holds.
All right, the court is going to order no return to Armani. Is this at the Sawgrass? Yep, it's 1700 Sawgrass Mills Circle. Do you understand, sir?
Yes, ma'am.
You go back there, sir, you get arrested. Okay, so court's going to set $9.99 on count one. Court will set $1 on count two. Count three is $9.99 and count four is $9.99. The other two are no bond. Judge Siegel this Wednesday. Good luck, sir.
Good luck, sir.
Henry Nelson. Good morning, Mr. Nelson. How are you?
Fine, are you, ma'am?
All right, you feeling okay?
Well, I was beat up by the police,
Don't talk about the police. Judge, he's not feeling okay.
Okay.
He has injuries, and we're going to get into that, Judge.
All right. So do we need an order for a medical screening?
Judge, I believe he's in the medical unit right now, but we are going to be asking for a photograph. Oh no, he's not in the. He's not in the medical unit right now. So, Judge, yes, we would be asking for a medical screening. And number two, we'd be asking you to sign an order allowing us to photograph the injuries that Mr. Nelson sustained.
Okay, the court's going to grant your request for a medical screening and for a photo order. So,
Thank you, Judge.
all right, so let me just get through this and tell him. Sir, you have aggravated battery on an officer, firefighter, EMT. We need to talk about bond. It says actually aggravated battery is count one. Count two is battery on an officer, firefighter, EMT. We need to talk about bond. Count three is possession of cocaine, $1,000 bond. Count four is drug paraphernalia, possess and or use, $100 bond. Count five is resisting an officer or obstruct with violence. We need to talk about bond. Count six is resisting an officer or obstructing without violence, $100 bond. And count seven is a capious misdemeanor. You are going before your division judge on June 4th at 1:30 p.m. So that's actually 2 weeks from today. I don't know if you want to call Judge Levy and see if you can get that sooner if he can't bond out. But that's June 4th at 1:30. Court does find probable cause. Anybody wish to be heard?
Yes,
State?
Judge, as to probable cause on count two.
Okay.
I understand that there could be probable cause for aggravated battery on a law enforcement officer, but I only see one officer who is battered in this probable cause affidavit, so I would object and state that there is no probable cause to support a second count.
Okay, State.
Your Honor, actually, count one, it's an attempted aggravated battery. The attempt being, and it was later discovered that Mr. Nelson had a weapon or a sharp, specifically noting a extremely sharp tire plugging rod, which was located in his pocket that he was specifically reaching into when the sergeant stopped him from reaching his pocket in this incident, ensued from there. In addition to that attempt, there's allegations that Mr. Nelson punched the sergeant in his nose and left eye. That would satisfy the battery on a law enforcement officer.
Well, then I would argue there is no probable cause to support count one. Mr. Nelson never obtained possession of whatever it was in his pocket. It doesn't really matter what was in his pocket because it never came out of his pocket. He never made any threats that he was going to use the item in his pocket against the officer. And aggravated battery or attempted aggravated battery would require an attempt to touch or strike the officer, and there's nothing to support that here in this probable cause affidavit.
Swollen left eye.
Your Honor.
Well, there is battery on a law enforcement officer.
Yeah. You're saying that's not aggravated?
No, the state is saying that's not aggravated.
Your Honor, the attempt requires one step in furtherance. He doesn't have to actually try to strike him with the weapon, merely reaching for the weapon, and clearly the attempt is evident based on Mr. Nelson's actions thereafter. But clearly, and that's why Sergeant Seapote specifically notes he was reaching in that specific pocket where it was later discovered to be this sharp, very sharp object. And then considering Mr. Nelson attacking the officer, there is probable cause to believe he was attempting to arm himself with this weapon.
I don't think that's present in this probable cause affidavit at all, Judge. I certainly don't think it's obvious.
Let me just ask the state this. State, where does it say that he was reaching for his pocket? Because I'm looking here.
It's the second page, Your Honor.
Okay.
1, 2, 3. I noticed the defendant kept trying to put his left hand into his...
Hold on, let me find that. I noticed... Okay, go ahead.
I noticed the defendant kept trying to put his left hand into his left front pants pocket in an effort to retrieve something, despite being told not to reach into his pockets. This action led me to fear that the defendant was trying to retrieve a weapon and use it against me to avoid being arrested.
Which he physically had to grab and remove. Okay, so the court is going to find attempt on count 1, probable cause.
Objection.
Okay, I understand. And state, battery on a law enforcement officer, obviously.
That would be for the punching of the face.
Count 3 is a residue count, Judge, if I'm not mistaken. I'd ask the court to take that into account, that it most likely will not be filed in light of count 4, the possession of drug paraphernalia. Also object to the probable cause on count 6. Again, we have resisting arrest with violence in count 5. I understand there's probable cause for that. But I do not see probable cause for both resisting with violence and resisting without violence.
Okay, state.
First sentence of the second page. Once outside the store, the defendant kept saying, "Get off of me, I didn't do anything," as he was tensing his body and pulling away from my grasp. That would be the resisting without violence.
It's all the same incident, though. It's all the same incident. It's the contact between the officer and Mr. Nelson outside the store. If the state's logic is correct, Mr. Nelson could be charged every time he touched the officer with battery. This is not a resisting with violence and a resisting without violence. There is one resisting. I understand that could be determined to be with violence, but there's no second resisting. It's all the same incident.
So you're saying there's one resisting with violence. You agree to that?
Yes.
But you don't agree to the without?
That's correct.
Your Honor, and I would just note there's different elements. If he does some act that resists or obstructs without violence and some act that resists with violence, he can be charged with both because there's a separate element in each offense that the state would have to prove. As opposed to Mr. Reedy's example of battery of the law enforcement officer, that's the same charge for every punch. There's no separate elements.
All right, court is going to find probable cause. Court will take it into account, Mr. Reedy, when I set bond. So what are you asking
Very well,
for
Judge.
on count 1 and 2? And 5?
Your Honor, the state would be requesting a $10,000 bond on count 1, $5,000 bond on count 2, $1,000 bond on count 5. In addition to the resisting without violence that Mr. Nelson is already out on and failed to appear in court, he also has a pending case before Judge Dennis Bailey that he's ROR'd on, and that's for shooting at or throwing a deadly missile, felony battery due to priors, and criminal mischief.
He has a pending case?
Yes.
For what?
I'm sorry?
What did you say? Shooting a deadly missile?
Shooting at or throwing a deadly missile, felony battery due to priors, and criminal mischief. He also, 2014, possession of cocaine, 2013, assault against a law enforcement officer, 2009, strong-arm robbery, felony battery due to priors, felony theft. He was sentenced to 46.5 months state prison as a habitual offender. battering 08, assault 08, corruption by threat against a public official 08. Those are the most significant relevant priors, Your Honor.
Okay, defense?
Judge, in speaking with Mr. Nelson, he's disputing these allegations. In speaking with Mr. Nelson, he advised me that he is the victim on this case. Considering that, Judge, he's 51 years old, been living in our community his whole entire life. He's working at a car wash. He gets about $65 per day. He lives in Dania Beach with his sister. My understanding on the case that he's currently out on in front of Judge Bailey, his next court date, I believe, is in June, maybe June 4th specifically. He believes on that day that case will be no prost. Having said that, Judge, Mr. Nelson asking me to ask the court to consider releasing him ROR. As you can see, Mr. Nelson was injured as a result of this altercation with law enforcement. He believes he is the alleged victim. In saying that, he wants the court to consider releasing him ROR on counts 1 through 6, Judge.
All right, this is...
And Judge, Mr. Nelson is just wanting me to ask, let the court know that he was injured as a result of the altercation, and he has lacerations both in his eye and on his face, Judge.
Okay, the court granted your request for a photo order. Is his address 805 West Dania Beach Boulevard, Apartment A?
Is that your address, sir?
Yes, ma'am. 805 West Dania Beach Boulevard. 805 West Dania Beach Boulevard, apartment number 8. Yes, ma'am.
All right, this is what the court's going to do. The court is going to put him on GPS level 2. Court is going to do a $7,500 bond on 1. What's concerning is there's a statement in here that says, for the first time in my 12 years, I utilized the officer in distress button on my portable radio. And just the actions of a defendant. So $7,500 on 1, counts 2 through 6 are ROR, count 7, the court will change the bond to $1. Thank you, sir. Good luck to you. Jamal Riley. Come on up, Mr. Riley. You have possession with intent to sell, manufacture, deliver, PVP, $1,000 bond. Count 2 is possession of cannabis. 20 grams or less, no bond attached to that, possession and or use, drug paraphernalia, no bond attached to that. Count 4 is not for a magistrate, it's actually a civil traffic infraction. Disobey a stop or yield sign, sir. And then count 5, you do have a no bond hold signed by your division judge, who is Judge Andrew Siegel. He's going before him on Wednesday, May 23rd at 8:30 a.m. on your no bond hold. Court does find probable cause. Anybody wish to be heard?
Considering he has a no bond hold, Judge, not at this time.
All right, so court will set bond at $999 on count 1, unless you'd like me to make it lower, and state has no objection. Anybody want to be heard?
I mean, if you wanted to set it at $99, Judge, we wouldn't have an objection to that.
On count 1?
Yeah.
Your Honor, my concern is it's the narcotic that he's allegedly in possession with intent to sell, PVP. Considering he's on probation for drugs, I think the $1,000.
Okay, $999. Thank you. Good luck to you. DeMar Gerard Dorsey, please.
Mr. Dorsey is approaching.
Good morning, Mr. Dorsey. You have criminal mischief between $200 and $1,000. First offense, $100 bond. Count 2 is carrying concealed firearm, $1,000 bond. Count 3 is resisting or obstructing without violence, $100 bond. Count 4 is resisting an officer or obstructing with violence. We need to talk about bond. And count 5 is not for magistrate, it's a civil traffic infraction. Improper stop, stand, or park. Court does find probable cause. Anybody wish to be heard?
Judge, in reference to count 4, I believe that's the only offense we're going to be asking you to set a bond. It's a third-degree felony. We'd ask you for a $1,000 bond.
State?
That's fine.
I don't see a dollar amount on to support the criminal mischief charge.
I'm fine with an ROR on that.
Okay, so court will ROR on count 1.
I would also object to the probable cause on count 2, carrying concealed firearm. Mr. Dorsey is not found with a firearm. He is
Hold on,
not.
which one is it? I was just writing.
Oh, I'm sorry, Judge. Count 2.
Okay, carrying concealed firearm, it says.
The report indicates that Mr. Dorsey was found with a holster, but
Inside
no
the
gun.
vehicle, a revolver found in the glove box.
And he was
Right.
seen removing a silver object from his waist. It's probable cause, Your Honor, and based on these
Yeah,
allegations.
court's gonna find probable cause. All right, so no PC on 1 per of state and the defense, ROR. Count 2 is 1,000, count 3, they're asking for 100 and you're asking for 1,000. You said no objection?
Oh, I'm fine with
On
1,000 on
count
count. There's for 1,000 on count 4. I'm fine with that.
Yeah. All right, so it's a total of $2,100 in bond, is that correct?
Yes, Judge.
All right, sir, do you reside at 4451 Northwest 32nd Court, Lauderdale Lakes?
Yes, ma'am.
All right, thank you very much, sir. Good luck to you. You get your court date in 7 to 10 days. Willie Norris Kelly?
Mr. Kelly, come on up, please.
All right, Mr. Kelly, you have DUI, alcohol, or drugs. This is your 4th or subsequent offense, sir. We need to talk about bond. Count 2 is DUI with damage to property or person of another, $1,000 bond. Count 3 is refused to submit to a DUI test. There's no bond attached to it. Count 4 is driving while license is suspended. First offense, no bond attached to it. Count 5, leaving the scene of a crash involving damage to property. Excuse me, no bond attached to that. And count 6 is a civil traffic infraction, not for magistrate. That is careless driving. The court does find probable cause. State, what are you asking for on count 1 and any special conditions?
Your Honor, in light of the fact that this would be Mr. Kelly's 4th DUI and involved a crash, I'm requesting a $10,000 bond on count 1. Further release conditions, should he post his bond, pretrial release with a TAD monitor, no alcohol intoxicants, and no driving, Your Honor.
Judge, what was the request the state made as far as monetary bond on count 1?
10,000.
Judge, in speaking to Mr. Kelly, we're going to be asking the court to consider a $2,000 bond. He's 55 years old, been here his whole life. He's currently working, he works as a dock worker. He's been doing that for 35 years. He supports his family. His wife is a stay-at-home wife. Their monthly rent is $1,500 a month. He's going to be contacting his wife to help post his bond. He believes that his wife can come up with the $2,000 with 1 and the $1,000 on count 2. Total bond would be $3,000. And I believe his last time being arrested on a DUI offense was about 2012, so over 8 years ago. So we'd be asking you to consider a $2,000 bond, Judge.
Court's gonna set a $7,500 bond on 1, leave the bond at $1,000 on 2, standard pretrial release. You're to report within 24 hours. Sir, you're to have no alcohol or intoxicants, random testing at your expense, TAD monitor, and prescription medication is allowed.
And Your Honor, as far as driving,
And no driving, sir. Do you understand? Until further order of court, even if you do get your license back. Do you understand?
Yes, ma'am.
Good luck to you, sir. You'll be getting a court date in the next 7 to 10 days. Okay, Mario Juarez, please.
North Broward, Your Honor.
Hello.
Hello.
How are you, sir?
I could be better.
All right. All right, sir, you have, Mr. Juarez, you have a felony battery. Court is going to find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the name of Ricardo Mendez do Nascimento. Do you understand?
Yes.
No contact, direct or indirect, sir, means no contact in person, calling, texting, writing, or through third parties, and absolutely nothing on social media. That means no liking, disliking, commenting, anything. Do you understand?
May I say something? I don't
No, don't say anything.
Okay, I understand.
Your Honor, I'm going to be asking the court to place Mr. Juarez on pretrial release. I don't know if the state objects. It looks like it was from the probable cause affidavit, one punch.
No, Your Honor, I would be asking for some bond in this matter, just since it's
What's
an
his priors?
out of Florida, he had a criminal mischief 2012. That was out of Aventura. Out of the state of Virginia, a DWI 2015.
So he really doesn't have an extensive criminal history, Judge. He has been living here for 8 years. He has family here, including his mother and his father. He works as a barber. He's also a student at the Boca Beauty Academy. And I think that he is, based on his ties to the community and lack of a criminal history, a good candidate for pretrial release. And I explained to Mr. Juarez before court the importance of not having any contact with the alleged victim in this case. He's certainly willing to abide by that condition.
What can you afford for bond?
He gave me his dad's number. I can call his dad and try and find out. I'd say maybe $500.
Which means his dad could come up with 500.
I don't know. I haven't spoken to his father, so
All
I don't
right,
know.
why don't we recall this and you can speak to his
All right.
dad. Have a seat, sir, okay? Or just stay there for a moment. Let's see if we can get in touch with your dad. We'll go sidebar. All right, let's bring back Mario Juarez. You spoke to his dad?
I did, Your Honor. He said he could come up with a $500 bond, but he'd have to go through a bondsman to do it.
Okay.
But he can do it, and he also says Mario has some money waiting for him at his job, so he can pay his dad back for bonding him out.
Okay.
Right?
All right, so state, you asked for, I'm sorry, say that again. You said,
I think I'd ask for $2,500.
okay. All right, court's gonna set bond at $1,000, sir. No victim contact, direct or indirect, okay?
Okay.
Your address is 3801 West Hillsborough Boulevard, B101, Coconut Creek.
Correct.
All right, thank you, sir. Good luck to you.
Thank you.
Thank you. Next one is Freddie Rice. Thanks.
He's here at Maine, Judge.
Okay.
Oh,
Thank you. All right, Mr. Rice, you have burglary, unoccupied conveyance unarmed, 2 counts. Court does find probable cause.
If I may, Your Honor, it appears
Sure.
that these are attempts.
Okay, state your response.
That would be correct.
And also, Your Honor, Nancy Hunnigan, pretrial services. He's currently on pretrial for case number 1800400 CF10A for attempt burglary, conveyance unoccupied, and resist or struck without violence. We're requesting that his pretrial is revoked, Your Honor.
All right, thank you. All right, so what we're gonna do is, Mr. Rice, you have counts 1 and 2 are burglary of an unoccupied conveyance unarmed. Counts 1 and 2, both are, we're gonna find probable cause for attempt only. On counts 1 and 2. State, what are you asking for as far as bond?
Your Honor, first of all, considering that, and I believe he was just placed on pretrial by Judge Pohl in a change of charge hearing last Saturday, I think it would have been the 12th. I'm gonna be asking for $5,000 on each count. In addition to his pending case, in 2015, he had a burglary of a conveyance, 18-month state prison. 2011, battering a law enforcement officer, 30-month state prison as a habitual offender. 07, burglary of a conveyance and attempted burglary of a conveyance, a year and a day state prison. 02, attempted burglary of a dwelling, 5-year state prison as a habitual offender. 02, burglary of a conveyance, 5 years as a habitual offender. 01, attempted burglary of a structure, a year and a day, and a grand theft auto in 2000, VOP, 16 and a half months.
Mm-hmm. All right, so, Vince, what are you asking for as far as bond?
Judge, unfortunately, speaking Mr. Rice, he's financially indigent. He's homeless at this time. He's not working. He's unemployed. He has no mailing address, so no one he can call to help post his monetary bond. So unfortunately, any sort of monetary bond, he's going to be with us for quite a while. Judge, I'd ask you then to consider releasing him on pretrial release. These are non-violent offenses, Judge.
Well, the problem is that he's out on pretrial release. When was he put on pretrial?
Last Saturday.
He was put on last Saturday, and he does the same thing again.
Allegedly, Judge.
I understand.
It's not allegedly that he was out on release on pretrial.
Well, the allegations, all right. This is what the court's, this is what the court's gonna do. The court is gonna revoke his pretrial. Court is gonna set bond at $500 on each count in the 18400 CF10A. And also put him on standard pretrial release if he does bond out. In the case, the instant case, he's to have no victim contact, direct or indirect, with the alleged victims in this case, with the initials MVE and ALC. Court is going to set bond at $1,500 on count 1, $500 on count 2. Thank you, sir. Good luck to you. This will go before the division judge. Oh, and hold on, bring him back.
Come back, sir.
Court's gonna put him on standard pretrial release as well. You can explain to him that if he violates Mr. Romero, that the court is he's probably gonna have a no bond hold from his division judge maybe. So, total is $3,000 bond. Thank you, sir. Good luck to you. Next one is Travis B. Howard.
Bonded, Judge.
All right, next one is Marvin Monroe Harp.
He's here, President Maine, Judge.
All right, Mr. Harp, good morning, sir. How are you?
Good morning, dear. I'm fine, and you?
Fine, thanks. You have a grand theft between $300 and $5,000. Bond is set at $7,000. This was done by Judge Howery.
Yes.
Anybody wish to be heard?
Your Honor, it says on the booking grand theft between $300 and $5,000. The allegations are really between $5,000 and $10,000. Also noting, it appears Judge Howery set the bond in conjunction with the alleged amount of money that was allegedly stolen from Mr. Harp's employer. So I do think it is reasonable in light of the circumstances. Additionally, Mr. Harp's criminal history, 04, possession of cocaine, 01, battery on a specified official with a violation of probation, 96, possession of cocaine, 95, possession of cocaine, violation of probation, 95, possession of cocaine with intent, also noting, Your Honor, it does appear that the money was not recovered.
Okay. Okay, sir, you're to have no contact and not return to the business called We Care For You. You understand?
Yes, ma'am.
When I say no contact, I don't want you having any contact with the owners or employees of that business.
Yes, ma'am.
Defense?
Judge, we're going to be asking you to consider a $1,000 bond on count one. Right now, Mr. Harp is working. He works at a plaza in Pompano. He's a porter there. He's been working there for a couple months now, making about $10 an hour. He's 40 years old, been living in our community now for about 28 years. He does have family that resides in our community. Most of the offenses, I believe that the state was reading off, the serious ones, were quite dated. Judge, he believes he's going to be contacting his brother, who's a cook, at a restaurant called Off the Wall to help post his monetary bond, and he believes if the bond is $1,000, his brother can come up with it. So that's what we're going to be asking for, Judge.
Okay, court's gonna set bond at $5,000. Thank you, sir. Michael Zysek.
Judge Isaac, come on up, please.
Okay, Mr. Zysek, good morning, sir. You have a burglary, sir, of an unoccupied conveyance unarmed. We need to talk about bond. Count 2 is possession of cannabis less than 20 grams. There's no bond attached to that. The court does find probable cause. Anybody wish to be heard?
Your Honor, I'd be requesting a $1,500 bond on count 1.
Judge, we're going to, unfortunately, Mr. Zysak's financially indigent. He's not going to be able to afford that. He's going to be asking for pretrial release. Right now, he is working. He works for CNH Concrete Company. He's been there for about 8 months now. He lives in Hollywood. He rents a room there. My understanding, Judge, he's been living here for over 20 years in South Florida. His last contact with the criminal justice system, I believe, was maybe some sort of traffic infraction in 2014. The last serious allegation, from what he informed me, was back in the 90s. So, Judge, he's promising to come back to court. We'd be asking you to consider releasing him on pretrial release.
Okay, court's gonna set $1,000 bond on count 1. Count 2 is an ROR. Is his address 1216 North Park Road, Hollywood?
Is that where you're living?
Yeah.
Yes, Judge. Judge, would Your Honor consider the $1,000 bond, go ahead and release him on pretrial release? It's been a while since he had any contact with the criminal justice system, Judge. These are nonviolent offenses, and rather than hoping him to, like, hopefully the state doesn't file within 30 days, that's gonna be his only way of getting out, is what he's informing me, Judge.
All right, this is what I'll do. He has a place to live, right?
Yes, Judge.
GPS level 2, ROR. Thank you, sir. Good luck to you.
Would Your Honor consider an open schedule so that he can work
What does he do again?
in construction?
All right, I'll do an open schedule.
Thank you, Judge.
I'm sorry, Your Honor. You are him just GPS open schedule, Your Honor?
Yes.
Thank you.
Edward Bryson.
Mr. Bryson, come on up.
Hello, sir. How are you?
Hello.
All right, you have grand theft of a firearm, $1,000 bond. Count 2 is remove a serial number from a firearm, $2,500 bond. Court does find probable cause.
Judge, I have an issue with probable cause.
Okay, go ahead.
This firearm was allegedly found in Mr. Bryson's room by, I guess, his mother, according to the report. There's no indication in here that he ever stole any firearm. A firearm apparently was stolen out of Pennsylvania in 2017. I'm guessing that's what the numbers mean, the OCA number. I guess that means it was the year 2017, although it doesn't specifically say that. But again, there's no indication that Mr. Bryson ever stole a firearm. There's also no indication that Mr. Bryson removed any serial numbers from the firearm. So I would argue that there is no probable cause on either count 1 or count 2.
Your Honor,
I'm tending to agree with Mr.
well,
Reedy.
for grand theft of a firearm, he doesn't actually have to commit the act of theft. Mere possession of a stolen firearm, if he knew or should have known it was stolen, there's probable cause then for grand theft of a firearm. And considering that the serial number had been removed, whether by him or someone else, certainly prior, at some point during his possession, is evidence that he should have known it was a stolen firearm, Your Honor. Someone that's lawfully possessing a firearm has no reason
So
to
that's
remove
for
a
the grand theft of the firearm. What
That
about
is-
count 2?
Your Honor, I would ask for probable cause for the lesser included, which is possession of a firearm with no serial number.
We also don't know if Mr. Bryson was ever in possession of this firearm. He's never seen in possession of it. No one testified that they ever saw Mr. Bryson handle or touch the firearm at any point in time. The allegation is that from his mother, what his mother says, is that she was cleaning his room and no one else ever goes into his room. And I honestly don't know how she can have that information unless she is in that residence 24 hours a day. So the fact that it's in his room is not an indication that it is his or that he had to be in possession of it or knew anything about it.
Well, this is a probable cause. Later on
I
down the
know.
road, that's
But it's still true.
I know. No, I understand.
Maybe she doesn't. Maybe she does stay there.
Yeah, maybe she is in the house 24/7.
Well,
I don't
then that should have been in the probable cause
That's for another
affidavit,
day.
Judge.
I understand. All right, so State, what are you asking for on 1?
I'd be asking for 1,000 on each count, Your Honor.
Defense?
1 moment, Judge.
Are you asking for no possession of any firearms, ammunition, or weapons, State?
Yes, Your Honor, I think I would be asking for that as well.
Judge, at this time, $1,000 bond, defense has nothing more to add.
1,000 each count, they said.
Yes.
Okay. All right, so 1,000 on each count. So count 1's 1,000, we'll keep it at that. Count 2, the court finds PC only for possession of a firearm without a serial number. $1,000 bond instead of a $2,500. Sir, you're not to possess any firearms, ammunition, or weapons. And if you do have any, sir, I want you to really listen to me. If you do have any, sir, you have to immediately surrender them upon your release to your local law enforcement. Good luck to you.
Good luck, sir.
Do I need to check his address? 813 Northwest 7th Ave, Apartment 3, Hallandale Beach.
Is that your address? Yes, ma'am.
All right, good luck to you, sir. You'll get a court date in 7 to 10 days. Look for it, okay? All right, Jonathan Michael Hilton.
Mr. Hilton, come on up. Judge, he's approaching and he declined the service of public defense.
Okay, Mr. Hilton, good morning, sir. You have
Good morning,
possession
Your
of cannabis over 20 grams, $1,000 bond. Court does find probable cause. Can you make the $1,000 bond?
Yes, ma'am.
All right, let me get your address.
2220 Southwest 9th Ave.
Allendale?
Allendale. Yes.
What happened to your face?
I was in an accident and I don't know, I was just bleeding after that.
All right. All right, thank you, sir. Good luck to you, okay?
All right.
Take care of your face when you get out. Jabari Days.
Mr. Days is approaching, Judge.
All right, hello, Mr. Days. You have resisting an officer or obstruct without violence, $100 bond. Count 2 is a probation violation. You are going to court before Judge Michael Rothschild this Wednesday at 8:30 a.m. You're going to be held no bond. Court does find probable cause. Court's going to set bond on count 1 at $99. Thank you, sir. Good luck to you.
Judge, would you consider $1 bond on count 1 as a
Sure.
misdemeanor offense?
Sure.
Thank you, Judge.
All right, last but not least. Good luck, sir. Last but not least is Patrick Lee Wells. Where's he?
North Broward, he refused.
Okay, Mr. Wells refused. North Broward, is that correct?
That's what I'm told, Judge.
Okay, defendant refused and voluntarily absented himself from court. All right, so court does find probable cause for possession of fentanyl, bond set at $1,000. There's no bond attached to resisting an officer without violence or trespassing occupied structure or conveyance. Does he have anything else pending?
Patrick Wells, I don't believe so.
All right, does he need some assistance or something?
We could set him tomorrow if you want, Judge.
Yeah, I mean, I don't just want him sitting in jail. But on the same token, he can't go back to racetrack. Seems like he's living there.
I wouldn't mind if you reset him for tomorrow, see how he feels tomorrow morning. He's been in a couple of days.
All
Based
right,
on the
let's
nature of the
reset
charge.
For 5/22/18 in the AM.
Thank you, Judge.
Thank you. All right, so North Broward, we're done. Conti, we're done. Paul Ryan, we're done. And Main Jail, we're done. See everybody back this afternoon. Thank you.